Oh, okay.
Good afternoon and welcome. My
Okay,
name is Derek.
we are now live.
Okay, thank you. Good afternoon and welcome. My name is Derek Lackey. I'm the managing director of Newport Thompson. We are a privacy and data protection consulting firm, and I'm also the chairman of the Response Marketing Association here in Canada. So, by way of further introduction, I think that I would like to just give you a little background. I've written a book on Castle, probably with a real focus on implementing rather than what the law says, because I think that most of us, I won't say don't care what the law says, but aren't as we're not looking at it from a lawyer's point of view. We're trying to operationalize it as marketers, and I found it was really a gap in the marketplace where there were a lot of people who were willing to tell you what you couldn't do, but there weren't a lot of people who were willing back in 2014 to tell us what to do. And that started me down this road of compliance and consent, and it's been a real ride. I've been on the GDPR, Canadian Advisory Council for GDPR. I chaired the work group on guidance, and we put out a very extensive document on what Canadian businesses need to understand about the GDPR if they operate in Europe. That's been a lot of fun. I'm also on the ISO 31700 committee, which is a global committee, and we are developing the ISO standard for privacy by design for consumer products. And we are pretty close. We have a plenary session coming up, and we're pretty close to having that final. I'm also the co-chair for the IAPP Knowledge Net for Toronto, the Toronto chapter. I'm in my second year of that. So I've been quite involved in privacy and data protection for about the last 8 years, but I do come at it as a marketer. And that's probably a little bit unique because it's mainly policy and legal professionals that are focused on privacy. So it's rather unusual to have a marketer who's focused on it. So I just wanted to set that context because I don't tend to get into philosophical discussions with lawyers about the nuances of the wording. I tend to look and say, what can we and can't we do? So here's what we'll cover today. It's Canada's Bill C11 is what CPPA is referred to, and I'll cover all the different variations in my next slide. But Canada's Digital Charter, May 2019. That is the fundamental 10 principles that this act is built on. Consent and consent management. We'll talk about what's changed over PIPEDA and which organizations are in scope. We'll talk about privacy management programs, and we'll talk about how CPPA will be enforced. So I plan to keep it very high level. I'm not going to get too much into the law other than referencing what it's asking us to do. So the CPPA stands for the Consumer Privacy Protection Act, as opposed to California, which is the CCPA, which is the California Consumer Protection Act. Little confusing and a little bit of alphabet soup. It's just starting to happen in the data protection world around the globe. More important, the hierarchy set by this Liberal government is that it's part of the Digital Charter Implementation Act. So the overall act, Bill C11, is called the Digital Charter Implementation Act. And within that, they have the CPPA, they have the Tribunal Act. It refers to several others like the Competition Act, CRTC, former PIPEDA, because parts of PIPEDA have been brought forward. So without further ado, let's look at some of uh, the 10 principles under the Canada's Digital Charter. It was designed as to develop trust in a digital world. And the minister believed back in May last year, 2019, when this was introduced, that it gave a framework for moving forward and making changes to PPPA. So one is universal access. And these principles are written from the point of view of the person whose personal data we're talking about, rather than the organization. So it's designed for safety and security. Uh, there would be control and consent. So right now, there's very little control given to the individual, and these laws are designed to change that. Transparency, portability, and interoperability. Um, Open and modern digital government. A level playing field. It's really what they're trying to achieve for business here, is that we're all singing from the same song sheet and we're all playing by the same rules, but we're not taking advantage of the consumer and abusing their privacy rights. Data and digital for good, a strong democracy, free from hate and violent extremism, and strong enforcement and real accountability. So those are the 10 principles of the Canada's Digital Charter. And they really gave the design of the CCPA and the tribunal and everything that's been proposed under Bill C-11. Just for context, Bill C-11 is now past the second reading. I believe it's moving to the FE committee, where the FE committee will do a public consultation and recommend any fine tuning and changes that need to be made. So all that we're talking about today is not final yet. So, but it is starting to give us a direction of how we should be designing our privacy management program, and what we should be taking into consideration moving forward. So because it's a consent regime, let's talk about consent and consent management right out of the gate. That to me is the most important statement that the law has made. We didn't go the way the GDPR went. The GDPR really gave businesses, there's 6 lawful bases of processing. 3 of them are designed for the private sector, and 3 of them are designed for government and institutions. And the 3 designed for businesses are, of course, consent is one of them, but contractual is also a legitimate lawful basis for processing people's personal data. And then the third one is what's called legitimate interest. And many people with the GDPR are considering legitimate interest kind of a catch-all. Some refer to it as the B2B clause in the GDPR that allows business to keep on, communicating and sending emails and all of that stuff. It's done in the legitimate interest of the organization. Canada didn't go that way, though, much to our surprise. Canada went straight to consent. And one of the reasons it surprised me is consent's hard to get. And in a world where we don't trust people with our data, consent's even harder to get. And I think the awareness around privacy and what people are doing with data is making us just even a little more defensive than we might have been even 5 years ago. So moving right to a consent with exceptions was kind of an unusual move for me. I thought that the lawful basis of processing context or framework made a lot of sense for the EU, and I personally thought we would adopt that, but we didn't. So Section 15 of the bill Bill C-11 states that the processing of all personal data requires consent. So that's a pretty clear statement. There's lots of explanation within the law of what that consent looks like and what collecting meaningful consent looks like. But then it goes on from section 18 to 51, which is 33 sections. It goes on to describe exceptions to requiring consent. And for me, while being clear, it's also it just makes it a little muddier. And by that I mean that um, I think as business people, we just want to know: do I need consent or don't I? And I shouldn't have to be a lawyer to figure that out. But with 33 exceptions, you're going to find when you're assessing your data as to what you actually need and use on a regular basis, you've got some decisions to make based on these exceptions. And if you do have to collect consent, it's pretty prescriptive as to how you must do so and what meets the measure of consent and what doesn't. So that would be, I think, the main checkpoint or check mark to pay attention to is understanding your obligations to collect and prove consent. It may take a little working with folks who do understand the law and who can interpret that, based on the way you're using data for this instance or collecting data in that instance, you do or do not need consent based on all of the exceptions. So that little bit of jiggering may require a lawyer or a privacy professional who understands all of the forms of consent and how they translate into implementation. As I was saying, Canada versus the GDPR, there's many differences, and certainly one of them is this whole idea of consent. Many people think that the GDPR is a consent-based regime, and it really isn't. There are 5 other lawful bases of processing that you can use people's data. Consent's only one of them. Canada is much more of a consent regime with this new law. And it's not terribly different from what, where Pepita was directing us. And but the biggest difference here is that the CPPA will be enforced aggressively, whereas Pepita was just I'm gonna call it a set of best practices encouraged by the government. Today, as you know, we just add them to the list. So, when we get people's data, we do what we want with it. We profile people using cookies. When they're on our site or purchasing anything, we're building a profile on them. And that's coming to an end. So you'll be able to do a little bit of that if they're a customer, but you still should respect and inform. So having consent and proving consent are 2 very different animals. And what I mean by that is most of us think that having consent is good enough. And the fact is, if you don't set up management systems to track and record your consent so it's auditable, then you don't have it. So the government's going to take the same position as they did with Castle. If you can't prove consent, you don't have it. So right now, all we do is add people to our list, and we don't know how they were sourced. So 5 years later, if you said to me, how did Derek Lackey end up on your list? You have no idea. You couldn't tell me. That's coming to an end. So we must set up systems to be able to track and record how Derek got on the list and what our promise to Derek Lackey was. In other words, what I mean by our promise to him is the purpose for collecting and using the data must be clearly stated when you're collecting the consent. So we'll get into it a little bit more, but it's not just throw them on the list and forget about it. You actually need to put a structure now in place to be able to know that if you were questioned as to why you're using Derek Lackey's data, you could go back to my file and say, oh, he gave us permission on this date using this web form, or he's in this log, or he used our preference center and set his own preferences. We're only doing what he asked us to do, things like that. So, and that leads me to my last point on consent is seeking to automate low touch, high frequency, because there's so much more to managing consent, tracking and recording it. Uh, I would really, we've been watching the market for years now, and we've seen, these all-in-one platforms that have preference management in them, but we've also seen completely separate, powerful preference management, consent management platforms that are starting to arrive in the marketplace that are software as a service, and they allow you to connect to everywhere you keep data in your system, and allow the consumer via a portal to change their preferences with you, whether it be cookies, whether it be on your email list, whether it be profiling them, whatever the type of consent you're looking for, you can chunk it into different types of consent and allow the consumer to manage their own and turn them off and on, and as granular as you want. That the data is then pushed out and exchanged with everywhere you keep data in your system. So some of these preference management systems like Serenus, Serenus has a one called Cassie that's we've been completely blown away with. It's very impressive, and it solves like kills 6 birds with one stone. So we really like the preference management direction in a world where all the data protection is moving towards consent. So let's look a little at what's changed. So if you look at PIPEDA versus CPPA, consent can no longer be assumed. There are some exceptions, but for the most part, they're saying that in order to process people's data and use it in any way, you really do need clear consent. And when you get consent, you have to give a purpose limitation. So I'll get into it a little bit more, but before I do that, I want to be sure I make this point that don't collect data you won't use. We've all had a bad habit of hoarding data because we could, or because we thought maybe one day we'd use it. If you don't have a plan to use it now, don't collect it, or in the very short term, don't collect it, because data is now a liability. Data can get you in more trouble with data breaches and not managing consent, and the possibility of fines and private rights of action and damage to your brand. Data, I think we pretty much looked at data as an asset for the last 20 years. And I think we have to start weighing that with data as a liability. Because depending on how you manage data and what you collect and use, data can very quickly shift from being an asset to a liability. Purpose limitations must be communicated and respected. What I mean by that is really simple. When you're collecting someone's data, their email address, for example, you need to tell them what you're going to use, how you're going to use it. And you can make broad statements, but they have to be specific enough so that me as a consumer, I go, no, I'd rather you didn't do that. And I have choice. So it must be communicated and respected. And I should have added there, and you must give people choice. So choice and transparency are key factors here. The CPPA will change the digital advertising landscape for sure, because what is collected and how it's used if you actually understood what was going on between in the ad tech world for serving up ads, I think many would be absolutely shocked. Uh, for example, I just saw a list. iMessenger collects uh, your health information. Now, why iMessenger needs your health information in order to send and deliver messages for you is beyond me. So it's completely beyond purpose limitation, and it's not even what an individual would reasonably expect, which is one of the exceptions to consent, by the way. Um, so I think you're going to see a serious impact with the introduction. GDPR is causing some change to the ad tech world, but CPPA and the new CPRA, the new law in California, which is going to add to their current CCPA, when they put those all together, the ad tech world is going to have to change how they gather and share data. Strong enforcement. I do have quotes on this because we'll talk. I do have a section here about enforcement, and it is the 10th principle of the Canada's Digital Charter. But the government's plan for enforcement of this. We'll get into it a little further in the presentation. Using personal data requires forethought. So this whole change is about rethinking how you use people's data, what you do, how you collect it, what you do with it, and what you don't do with it. And if you want to do something beyond the purpose limitation that you collected it for, you simply have to go ask. And it's if you've built trust with a customer or a prospect, you'll likely get that consent. Now, I think that for the first few years of the CPPA being enforced, the consumer's not going to trust us with their data because we've given them lots of reason not to. And we've given them now 20 solid years of knowing that they've got no control and that we're going to do what we want to do with it anyway. So that's going to take some time to change. That's not going to spin on a dime. And but I think that over the next 10, 15 years, you're going to find that this trust starts to happen, and brands that are trusted to do the right thing with data will get consent much easier than brands who are doing questionable things on a consistent basis. Understanding your prospect and your customer, it becomes critical because now you're relevant to them, and their engagement with you should go up if you build trust with them. But it really is going to take a change of mentality about A, who owns the data, and B, what can and can't be done with it. And then I'll circle back to this track and record. I can't emphasize enough. In the past, we have not had to prove consent or how they got on the list or why we do what we do. None of those questions have been asked. We just have been free to do what technology allows us to do. And I think even in there, we forgot to ask, should we do this? Because just because technology allows us to do it doesn't really mean that that's what we should do. So I think we need to get kind of back focused again and put the customer first, and rather than this quarter's sales. Which organizations are in scope? This is actually very interesting in my opinion because there's the data protection laws around the world have taken a very different stance on this topic. So for Canada, all organizations who use personal data are in scope. So they don't care if you're a two-person company. If you keep personal data and you use it, you process it in some way, the law applies. So unlike California, which has an exclusion for small businesses, so California has an either or one of these three things. If you're less than 25 million in sales, doesn't apply. Or if you keep 50,000 plus or 50,000 or more files, or if you keep less than 50,000, let me put it that way, it doesn't apply. And if less than 50% of your revenue comes from selling data, it doesn't apply. So it's not all of these things, it's any one of these things. So it's a or rather than and. So if I'm evaluating for a customer, I'm looking at um, these three outs. Uh, we've had many of our clients who were very concerned about complying with CCPA in California over the last couple of years. We've been able to tell them, look, don't worry about it. You're under 25 million, or you don't keep more than 50,000 files, or you don't sell data, so it's not part of your revenue stream, so it doesn't apply to you. Um, we we thought that was a pretty reasonable um, expectation of the marketplace. And I think the major abuse of personal data is not coming from the small businesses. I think that most of it's coming from social media and the tech companies. And then second to that would be large corporations who are amassing tons of data on you, like our telco companies and our insurance companies and the banks. And they keep larger files on us than we might think they do. So at this point, Canada does not have a small business exemption in any way. So do I think that that could change with the Ethics Committee, public consultation? I think there's going to be a heavy lobbying between now and the time this bill gets passed by the small business community and the organizations that represent them to have some kind of small business exemption in there, whatever that looks like. California chose to do it this way. I can't imagine that this bill is going to get passed and apply to a hairdresser who has 4 employees and keeps a customer database. They suddenly now have tons of obligations under this new bill to regarding personal data. So I will go over those. The privacy management program requirements, and I think you're going to be shocked at what the government expects every business to do given this new law. So there are lots left between now and the time this becomes law. So the Ethics Committee and the governor's regulations will have an impact on the details. So what we're seeing is not the final law, far from it. In fact, there were many areas of it that need to be cleared up by additional regulations. And even there's spots in the law that are call for additional regulations. So we're a long way from this set in stone and being able to tell you exactly what to do, but we can tell you the direction it's heading. So keep your eyes and ears open. Probably won't come into force for a couple of years. They're going to take a little bit of time to get it right, and then they're going to take a little bit more time to give us time to put programs in place. But once it starts being enforced, I think you're going to find lots of fines. So let's talk about the privacy management program. So under this new law, every company who collects and uses data in any way has to have a privacy management program. And what that means is that you have to create a data map. You have to understand all the data under your care and what you do and don't have consent for. Excuse me, drink of tea. We would recommend writing a gap report. So measuring your current practices versus the new CPPA requirements. from there, you can create a project list that you can begin working on. So if you have a couple of years between now and the time CPPA is being enforced, you have lots of time to start setting things up and start knocking things off without panicking. What we've seen with most laws like the GDPR and Castle, um, most companies waited till like 6 months before it was coming into force to do anything about it. And if there's one thing I could stress to you, don't do that. You've got lots of time now. You can see the direction the laws are heading. You should start to make changes to your privacy management program. You should start to really understand what data you have and how you use it, and what could be deleted from your system. Because with data breaches um, and all these new laws, quite frankly, it has become a liability, as I said earlier. So you have to truly rethink the organization's use of data based on today's priorities. So just because you've always done it that way is not a reason to keep doing it that way. And you're already seeing that consent's going to be required, and it's the respectful thing to do anyway. So let's start asking for it. Let's start changing our habits and only doing what we think is right for our customer and our prospect and customer, rather than what technology allows us to do. So, and this is tricky. I doubt that most small business have a policy and procedure manual for privacy and security. But this law does require you to document your policies and procedures, and then use that documentation to train your staff. Again, I doubt that a small hairdresser is going to have a policy procedure manual about anything. But this law requires them to have one about privacy. Now, it doesn't have to be a particularly thick one. So I would suggest to you that the small hairdresser's policy and procedure manual might only be 7 to 10 pages, whereas a large organization like a Rogers or a TELUS is probably a 500-page plus manual. So, and then I would recommend sourcing automation to manage consent. I mentioned this earlier in the consent module, but I can't stress enough that that manual procedures that to manage consent is just, you'd never keep up with it, and you're not going to be accurate, and you're not going to be able to be truly auditable. And then creating regular privacy reviews and updating the program. So many of our clients have set a policy of annual reviews and quarterly updates on any policies and procedures, because there's always things happening and things changing, and it doesn't say that you can't be flexible and nimble, but it does say that you need to set up a process for it. You need to understand what the policies and procedures are within your company and how it operates. And you probably do need to revisit your privacy reviews, privacy program, and how you manage it and what the policies and procedures are every year, and maybe revise staff training to reflect any changes that you've made. And it's not that difficult. We've had lots of companies who want us to train them on the GDPR, and we kind of resist that, because most sales forces that I've been in front of rooms of hundreds of thousands at a time, their eyes roll when you tell them about the GDPR. All they want to know is how their company handles privacy and what their obligations are regarding that privacy. So training them in the GDPR is a booby prize. Training them in how your company handles the issues within GDPR, that's meaningful. So this is pet peeve. I've done a few rants on this on LinkedIn and on the RMA blog, the Response Marketing Association's blog. How will the CPPA be enforced? One of the 10th principle in the digital charter was strong enforcement. And, when I look at how enforcement is set up within this Bill C-11, I question whether strong enforcement could even take place. So let's start with above enforcement. If you take care of your customer, they'll be loyal. And if you can be trusted with their data, they can be even more loyal. Do this for your brand and your brand reputation. Don't do it because you have to comply with the law. Do it because it's the right thing to do for your customer and your prospect. So that's the kind of the first level of enforcement that I would address is, are we doing the right thing with our customers' data? Or are we, excuse the phrase, but bending them over the barrel, which many companies have been doing for many years. So the first thing is take care of your customer. But it's important for you to know that under enforcement of this Bill C-11, you can be fined up to 25 million or 5% of your annual revenue in very egregious instances. There's a standard lower than that, but I just thought it's easiest to communicate to you what the maximum penalties are under the law. And right now, the Canadian government can say, these nice little sound bites, that this is the most strict enforcement standard of any data protection law in the world. For example, the European one for the GDPR is maximum $20 million or 4% of revenue. So Canada has come in setting a even higher standard of ability to fine. So how this is all going to work is quite interesting. The Privacy Commissioner of Canada, the Privacy Commissioner's office will conduct all investigations. And at the end of their investigation, they will make a recommendation to the tribunal. The government's proposing a new tribunal be set up consisting of 3 to 6 individuals, one of which has a privacy background. The others are simply patronage appointments. And these 3 to 6 people will determine the fines. Now, it'll be partly based on what the Privacy Commissioner recommends. But I find it hard to believe that unless that tribunal is a group of very informed privacy professionals, it's going to be hard to get it right. Because how does a non-privacy professional judge the work of the Privacy Commissioner's office? I scratch my head. So I think that between now and the time the bill gets passed, you're going to see a little bit of a change to this structure. I'm not sure if the tribunal will be part of the Office of the Privacy Commissioner's office, operating separately, but be part of the office. I don't know which way it's going to go, but I think this proposed enforcement is troubling, to say the least. There's just layers of bureaucracy that are not really required. If you look at the way Castle was enforced by the CRTC, there were 3 bodies who could enforce Castle, but the primary enforcement body was the CRTC. And, until the private right of action was removed, the CRTC did in my opinion, an exceptional job of enforcing. They let the market know what they were going to enforce for. They gave some sample fines out. They spent the other half of the 3-year period, grace period that we were all given. They spent the last 18 months of that 3-year period building memos of understanding with other countries so that they could enforce this law internationally, trusting that when the private right of action came in, which was going to be the primary tool for enforcement, that they would be left to focus on malicious stuff and the stuff we would expect them to go after. So the design of the enforcement of Castle, I think, was far better than the design of the enforcement for CPPA, but time may prove me wrong. And I would certainly happily be proven wrong in this particular case. One of the other troubling things for me is there's enough of a private right of action within this law, enough to say that there is one, but in all honesty, this private right of action is let's put it this way. I can't ever, I'm not a lawyer, but I can't ever see it being triggered. And what I mean by that is it's written into the law, but you have to be able to survive all the appeals of the Privacy Commissioner's investigation. Then you have to be able to survive all the appeals to the tribunal's decision. That can be appealed as well. And then only after the tribunal finds them guilty and fines them, only then can a private right of action be registered against a company or an organization by an individual. And the other tough standard that any lawyer will tell you is incredibly hard to prove is that you have to prove that there were damages as a result of your breach or your information being made public, or whatever the circumstances are. You actually have to prove damages, and any lawyer will tell you the bar for doing that is incredibly high. So I think while we can say there is a private right of action attached to this law, it's not a meaningful one, and it's certainly one I think you're going to be in very rarefied air to see private right of action being levied under this law. So, I think it's a bit deceiving with these fines of 25 or 5% and the private right of action. It sounds tough. How it actually gets enforced, I guess we have to see. But if it's anything like Castle, this government has no appetite for penalizing business in any way. And the enforcement of Castle was not meant to be a penalty, but it was meant to bring companies into compliance. But still, they resisted. I think in the last 3 years, the CRTC has issued 3 fines under Castle. So strong enforcement, I can't call it that. I will give the benefit of the doubt, or maybe I won't. Maybe the government's going to have to prove to me that they understand what strong enforcement truly is. I just question whether the structure for enforcement on this law is sufficient to be called strong enforcement. So hopefully that'll all get addressed as we go through the FE committee and the public consultation, as well as the writing of regulations. And then finally, the actual enforcement of the law through the Office of the Privacy Commissioner, as well as the tribunal. So it all remains to be seen, how strongly that's going to be enforced. They did give the broad tools, but let's see how it goes. Let's see where enforcement falls on this one. Again, though, as business people, let's also consider that compliance and enforcement is the wrong reason for changing your data practices and respecting people's privacy. It really should be about your consumer and about taking care of them, and not about complying with the law or avoiding penalties. I hope, I'm optimistic. I hope that we get back to a world where we actually start taking care of our customers again, and put them first rather than our shareholders and our executive compensation and our quarterly reports. So I can go on for days on some of these topics, as you can appreciate. So I'm happy to take any questions. We've got about 15 minutes left. And please use the Q&A or the chat. If you have a specific question that is specific to your company, please feel free to reach out to me, and I'll do my best to give you an opinion on it. Got a question here. What about context that you have had in your database for a long time? There will likely be, if you look at the way Castle was handled, there will likely be a transition period that you can seek consent from those individuals and resource how they get on your list. But at some point, you're going to have to lose them. So Castle was made, came into force in July 1st, 2014. And between the period of 2014, July 1st and 2017, July 1st, that gave you 3 years to convert your list and to resource it and to seek the consents that you needed. And on that 3-year anniversary, any that you couldn't resource or understand how they got on your list, you should have cleaned your list. You should have deleted them. Many people did not. So I know lots of companies who are dealing with 10-year-old lists and don't know 3/4 of their list how people got on them. It's a very dangerous space, because if you're emailing people, for example, if you're emailing people and you don't know what your consent is, you're actually breaking the law and you could actually be fined. So an old list that you don't understand how they got on your list and what consent you have, I'm going to suggest you don't have consent. Question here, when can we expect this to be enforced? So here's my best guess at a timeline. It's going to take this year to actually pass this law. And then we're going to probably have a year to 18 months between the law actually becoming final and the regulations being introduced, so that we understand exactly what this is. We'll probably have an 18-month to 2-year max, I think, period. So what's that take us? So 2001, 2002. So, I would say that the data you're managing in 2023 will probably come into effect under this law. So while they may not enforce for 2 years, they will likely enforce based on a year prior. So if that makes any sense, I would say you're looking at January 2023 to have your habits changed and your new policies in place. And so lots of time for you to do your homework and start taking these in small chunks that don't have to be expensive, but start working you towards being a compliant program. And then your last 6 months before it actually comes into force, you're just tweaking some of the policies and procedures and making sure. So that would be my best guess. But at this point, it's a guess. the ISED minister has just changed hands. Minister Baines has resigned, and Minister Champagne has taken over. We've heard very little from him regarding this law, but he's only been in the office for a month or so. So I'm sure we will hear from him. But more important, I'm sure we'll hear from the Ethics Committee, who are doing probably within the next 30 or 60 days, we'll be opening up public consultation regarding Bill C-11. Do you think the definition of personal data is changing? Without question, it's changing, and the GDPR had a significant impact on that. So, the definition of personal data prior to the GDPR did not include an IP address, for example. IP address is not necessarily tied to an individual, it's tied to a company sometimes. But they consider an IP address as a potential personal data. So what they're considering, so if you can take any 2 or 3 pieces of data and string them together to figure out that must be Derek Lackey, that's now considered personal data. I think that what we're seeing as what we call sensitive data, or the real serious personal data, I think that's been defined for a while under all of these privacy regulations, including PPPA, had very good definitions of what personal data was and wasn't. But yes, it is changing, it is broadening, and it's changing based on how technology allows us to use people's personal data and what we're able to do with it. AI is going to have a significant impact on what we call personal data. So yeah, I think you need to kind of lean in and pay attention as to what is and isn't considered personal data. We have another question here for where can we obtain more information on the CPPA? There, if you Google Bill C-11 or CPPA, you'll hit the government website that gives you more details on it, including checklists and based on the language so far, what things like we talked about here today that you could be starting to do to be compliant in 2023. And if you want to look up the law itself, you can go to the House of Commons and look up Bill C-11, and you can actually read the law. And, I really do recommend it. I remember the first time I read Castle, I was surprised at some of the things that were in there as a marketer. And, sometimes reading legalese and laws is not much fun, but I would, if you're serious about taking your customers' privacy seriously, I would really recommend taking time to read through the law and go, oh. And I find that I've read Castle hundreds of times, literally, and I still learn stuff when I read it. So there's all sorts of little nuances in there and interpretations. And now that we're into the marketplace, you can say, oh, that's how they're interpreting that. So, all right. So those are all the questions. And I thank you very much for your time and attention today. And please don't hesitate to use this contact information, reach out to me. You do have my consent to email me. Just kidding. God bless and thanks.